In the winter of 2019, across India, there were shouts of revolution and freedom, of the Constitution and secularism, of the freedom of speech, the right to protest non-violently. Not too long after these protests started, there were severe restrictions imposed by the government, preventing gatherings and protests, jailing activists, and even leading to a ban on protests at one point. But wait a minute, how can this be? Doesn't our Constitution guarantee the right to free speech and expression? Aren't peaceful, non-violent protests baked into the DNA of our nation? Hello and welcome to Contested Nation, a podcast that discusses how the Constitution of India was written and how that remains relevant for India today. I'm Shruti, your host. This podcast is produced by Suno India in collaboration with the Equals Project. In this episode, we explore the complicated history of the restrictions on the right to speech and why this right remains heavily contested today. While the Constitution of India was formally written between 1946 and 1949 by the Constituent Assembly, the process of constitution making itself was happening throughout the independence movement. As those in the freedom movement were fighting for independence from colonial rule, they were also simultaneously articulating their vision for this new nation. A constant question was, what kind of constitution shall a free India have? And just like in any group project with lots of different people, there were a lot of different visions for what the constitution should have. In 1895, there's a lesser known document called the Constitution of India Bill 1895, or the Swaraj Bill, which presents one of the first legal articulations of the right to free speech in India. There was common consensus that there should be some sort of fundamental rights in independent India. The right to free speech, free press, freedom of association and assembly. All of these were first proposed in the 1931 session of the Indian National Congress. At this session was the first resolution or the first articulation of civil liberties and social rights that the Congress hoped would form the bedrock of the new Indian nation. Along with the official Congress articulation, there were others who were writing draft constitution in this time period.
To discuss this episode with us, we have a very special guest. A very warm welcome to our guest, Maitreyi Krishnan. Maitreyi is a lawyer based in Bangalore. She is particularly interested in the unorganized sector and works to provide legal support to the Domestic Workers Union and the Paurakarmikas Union. She's the president of the All India Lawyers of Association for Justice. She's also associated with the All India Central Council of Trade Unions. We're really delighted to have Maitreyi join us today, not just for her perspective as a lawyer, but also to bring her perspective as someone who works with workers and people's movements and sees the everyday implementation of people's movements and organizations and how they are impacted by restrictions on the right to free speech. So welcome, Maitreyi, and thank you so much for joining us today.
Thank you for having me.
Amongst the various draft constitutions that were written, there was a pretty radical one called the Draft Constitution of Free India, by a communist leader, freedom fighter, and Marxist revolutionary M.N. Roy. M.N. Roy, incidentally, is the first person to have even proposed the idea of a Constituent Assembly. What M.N. Roy sought in his draft constitution was the absolute right to revolt against tyranny and oppression. According to him, this should be a fundamental principle of the new nation. While all the other drafts had inbuilt some sort of restrictions on the fundamental rights, M.N. Roy veered in the exact opposite direction. arguing for a fundamental right to revolt, which seems pretty radical even thinking about it today. So, Maitreyi, let's start there. Let's talk about this absolute right to revolt. Where did this idea stem from, and what did that mean for people's movements and freedom in India?
Thanks, Shruti. I think the idea of the right to revolt that Emin Roy talks about remains very relevant today in the situation that we have. In fact, incidentally, I just came from the worker struggle which has been going on for 244 days. This is a struggle of workers of the Indian telephone industries who are all dismissed, who are all terminated for the sole reason that they actually came together, voiced their right to organize and demand what was theirs. They unfortunately now termed contract workers, which is another word for bonded labor. These are all workers who had actually come out and said that they wanted their fundamental right to organize, their right to dignified working conditions. And for this one reason, in fact, they had all been dismissed, and their struggle is going on in Bangalore today, and it's their 244th day. So it's very interesting that we are talking about the right to revolt against oppression and tyranny when we have across wherever we see, we will see that there are these acts of revolts against oppression and tyranny that we can, if we actually look, we can see all around us. So it's very interesting that we are talking about this today. So thank you for putting this out. If we look at what M.N. Roy also spoke about, the context in which the statement on his right to revolt was made is it cannot really be seen in isolation. It's made cognizant of the fact that there is a continued need for revolt even after the colonial rule were to end. And this is something that's recognized not only by him, but by Dr. Ambedkar, by Bhagat Singh, several of our freedom fighters who recognized that the mere end of colonial rule would not mean that a just and equitable society actually comes in. And therefore, the need to revolt against oppression and tyranny is something that is very essential. If we look at, in fact, what Bhagat Singh says, where he talks about what happens if the colonial rule were to end, and he says that unless there is substantial change that is made in the form of society itself that we are living in, the mere change of ruler from the imperialist ruler to what he says as a brown ruler would be completely insufficient. So the idea of the right to revolt is something that is really premised on that, and that is something that even Dr. Ambedkar speaks about, where he acknowledges in his famous speech on the grammars of anarchy, where he acknowledges that even as we come into a constitution, we come into political equality. But insofar as social and economic equality is concerned, there may be one man, one vote, but the social and economic equality is really missing, and something that really needs to be done on that. So I think the statement of M.N. Roy has to be also looked at it in that context. Interestingly, when he talks about the draft constitution, he looks at it in the principles of democratic freedom. And there's another thing that he actually says, and where he says that the supreme sovereignty belongs to the entire people. The people have the right to alter and modify the political organization of society, and the land and the underground riches are collective property of the people. So this is a larger imagination where your right to revolt is linked to a society that looks at social and economic equity, social and economic justice. So I think it's in that context that statement that was there in the draft constitution, and like I mentioned, it's something that is absolutely essential today. And if we look at our constitution that we have, we would also see that the right to I would not say revolt, but the right to demand for a society that is equitable, that is a society that is equal, a society where there is justice, is something that the constitution has as its vision, and that is there in the chapter on the fundamental rights, and that is in fact something that one sees running in the chapter on the directive principles as an obligation of the state. So there is a dream of a society that is equitable, equal, and that is premised on social, economic, and political justice that we have. So the idea of the right to revolt, which was put forth, the idea that there is a need for continued struggle against oppression and tyranny, I think is something that was acknowledged by everybody. At some level, if it is a part of the constitutional dream as well, when we are looking at a society that is fair.
I think that's a fantastic point, tying in this right to revolt or the right to free speech, really, which is what M.N. Roy is also tying it to the demand for a fair, equitable, and justiciable society. And this is something that we see as we move into the Constituent Assembly and the discussions in the Constituent Assembly on the right to free speech. I think this is an argument that comes up quite often. But Maitreyi, one question I have for you is this right to revolt in in the form that M.N. Roy articulates doesn't actually make it to any discussion in the Constituent Assembly nor any draft. Does that surprise you?
I think the right to revolt, in fact, if I'm not wrong, even the Supreme Court, where it talks about when it's discussing the question of sedition in the Kedarnath judgment, there is one portion of that where they actually talk about how much you can speak out against the government, how much you cannot speak out against the government. So the idea that the state is somewhat sacrosanct and must be preserved is something I think that is there, that is prevalent. A Marxist understanding of the state would really require us to look at it as part of and try to understand it in a historical context where we see it as becoming necessary in order to check the contradictions, especially of class, that exists in society. And such a state would never recognize the right to revolt against that very state. The right to revolt was not really discussed. I think that when one is looking at forming a state, when one is looking at entering into a kind of new era, perhaps the right to revolt was not discussed. But discussions that go around freedom of speech and expression, the discussions that go around the various other freedoms, certainly recognize that there's a need to disagree with what the state says. There is a need to recognize that not everything's not going to be sunny going forward, and there's a need to recognize that people's demands would have to be able to be put forth, that people have the right to continue their struggle towards a society that is equal against various forms of structural oppression, and I think that it remains.
Overall, by 1946, when the Constituent Assembly begins to formally meet, there was a sense that fundamental rights, including the freedom of speech and expression, would be central to the new India. However, there was also a sense that there needed to be some restrictions on this free speech. The draft proposed by the Subcommittee on Fundamental Rights included two exceptions to free speech: public order and morality. And in 1948, as the full Constituent Assembly was heatedly discussing the fundamental rights, the thorny issue of restrictions was one that repeatedly raised its head. This was a question or a restriction that deeply disturbed several members of the Assembly. After all, weren't these the very restrictions that they had fought so hard to be free from? During these debates, an emphasis was laid on the spirit of the Constitution, a spirit that many felt was essentially anti-colonial in nature. Those against restrictions on free speech argued that by imposing colonial-era restrictions, the Constitution was becoming the very evil they had fought so hard against. Many feared that such restrictions would perpetuate the same cycle of oppression, the difference merely being the nature of the government, which was superficial.
I want to ask him why the fundamental rights, if indeed they are fundamental. Why are they being qualified by putting so many provisos?
That was Arun Guha, an Indian National Congress member from West Bengal. What is being given by one hand is being taken away by the other, thundered Sardar Bhupinder Singh Mann, a Constituent Assembly member from East Punjab. He argued that free speech was particularly important to minorities, as this was how they would be able to raise their voices against an unjust majoritarian government. Syed Karimuddin, a member from the central provinces, cautioned against placing too much trust within the legislatures and parliament.
I am constrained to say that these are fundamental rights from a police constable's point of view and not from the point of view of a free and fighting nation.
That was Somnath Lahiri, a member of the Communist Party from West Bengal. Members questioned the sacredness of the state itself. In fact, Tajamul Hussain, a member from Bihar, exclaimed, "It is a free country. If the people want to have a revolution, let them have a revolution. What right do we have to prevent that?" Those in favor of the restrictions were deeply influenced by the violence in the country and amongst its neighbors. India was suffering from large-scale violence on account of partition. The father of the nation, Mahatma Gandhi, had been assassinated mere months earlier, and there was a fear that the collapse of the Indian Union might not be too far away. To many, the need of the hour was to strengthen the Union and ensure its survival. There were also others who believed restrictions on free speech were necessary to protect minorities. Dr. Ambedkar himself was a proponent of this view and focused on the public order restriction on the freedom of expression. He pointed out examples of caste violence and incitement to violence and expressed his distrust of unrestricted free speech when framed by a society of extreme inequality and oppression. In October 1949, contempt of court was included as yet another restriction on free speech. While many in the assembly had misgivings, and those in support had different justifications, ultimately, restrictions on free speech were seen as necessary for the greater good.
I'm curious, Maitri, to get your opinion on how restrictions of free speech are framed by governments, by courts, by politicians today. Does it How does it compare to the restrictions that I just laid out by the Constituent Assembly? And what are the reasons that we use today to justify restrictions on free speech?
I think before we just go into looking at how free speech, there are justifications made for free speech, whether it's by the government of the day or whether it's by the courts. I think it would also be essential for us to look at what we really mean when we talk about free speech, because the fact of the matter is that irrespective of the restrictions that we have, irrespective of what the justifications that the government or the courts may give, there are certain structures of oppression within society which do not allow for free speech to really exist in the way that we would probably want. So let's say, for instance, you look at caste. With the existing caste structures that one has, can one really say that there exists freedom of speech? Idi Amin says that there is freedom of speech, but I cannot guarantee you freedom after speech. So what happens to people who choose to exercise this freedom of speech, and whether that right really exists? So for example, if you look at something like caste, like what I was saying, whether Dalits, even today, whether they can speak out against those from dominant caste, and if they do speak out against those from dominant caste, what are the repercussions that they face? If you look at the various caste atrocities that have taken place across the country over the last several decades, ever since independence, one will really see that any exercise of any freedom, including the freedom of speech, has resulted in atrocities that one can't imagine, right from torture to killings. For instance, you look at what happened in Batni Tola in Bihar, where Dalit workers demanded minimum wages. When didn't come through, then they boycotted work. That led to a massacre where 21 Dalits were slaughtered, including 11 women and 6 infants. So I'm saying that when we try to look at free speech as a society, is it a society that allows for free speech to even exist? Because what the society that we have today is one that is highly divided, that is highly unequal. Similarly, if you look at something like patriarchy and whether women can really even speak out against what they believe is wrong, and the fact that they are unable to speak out, the idea of free speech itself is so alien, then it allows for systems of patriarchy to continue to exist. So when we are speaking about free speech, I think it's also essential to recognize that there exists structures of oppression within society which really don't allow for free speech to exist as we would want them to, irrespective of what we understand as reasonable restrictions that that come from the courts, or from the government. Coming back to your question in respect of the justifications for free speech that we see today, the fact of the matter is that the government, the union government, the ruling dispensation at the at the central level is one that believes in an ideology that believes inherently in inequality, that believes inherently in certain people having rights and certain people not having rights. It's an ideology which believes in propagating the caste system. It is an ideology that believes in patriarchy. It's an ideology that believes that religious minorities, whether it's Muslims or whether it's Christians, they don't have the rights that a small minority of the population has. So it's an ideology that believes in inequality. It's an ideology that believes in violence for any breaking of these rules. So when you have a government, when you have a dispensation that believes in an ideology that is fundamentally contradicting the values of the constitution, I think one can only imagine what is the justifications. Which is why today you see such a strong assault on the idea of free speech itself. So whether it is the government that believes that you can incarcerate people for years on end for criticism that they may have made of the government, or for anything at all that it's not happy to hear, or whether it is the fact that the government allows for organizations to actually go about creating violence against people who choose to exercise the freedom of speech. The reasons for stopping it stems from the ideology that they believe in. So I think if you look at the kind of things that we have heard over the last few years, the whole idea of labeling people as anti-nationals, the idea of saying that certain people don't have the right to speak, and if you don't speak, you're either an anti-national or you're an urban Naxal. That means that anything can be done to you. These are the kind of justifications that we are seeing today, whether it is from the government or whether it is from political leaders belonging to the ruling dispensation. So if we look at that, I think we really need to recognize one, of course, that the attack on free speech that is coming and the justifications, if you can call it that, for restricting free speech that is being put out, and what the impact of that is. When you're attacking free speech, effectively, it's not only speech that's getting attacked; it's effectively the entire person that gets attacked. It's your various other freedoms, your various other rights that get attacked. So I think that the fact that today we're talking about free speech, the fact that we're talking about the justifications for free speech, it has to be placed in today's context where there is a very clear onslaught on the idea of this free speech itself, and it stems from an ideology.
I'm going to challenge you on that a little bit, Maitreyi, because I mean, history suggests that no matter what the ruling power is, it's interested in preserving power, preserving its ideology, whatever that ideology might be. Okay. So if you look at the First Amendment to the Indian Constitution, uh, it's it's sort of triggered by the fact that there is a growing communist presence and a growing communist ideology in certain parts of India. One can argue that that is the ideology that the government of that day was fighting against. That fundamentally, the any restriction on free speech or any backlash against criticism of the government is about preserving power, no matter who is in power, no matter what the ideology. And we see this across the world, we see this across different governments and different ideologies that have come to power in independent India itself. How would you respond to that? That it is about preserving power and preserving whatever the ruling ideology is, and not restricted to any one ideology.
See, the fact that you had reasonable restrictions being put in at that point of time, there was a certain understanding of preservation of power that was felt necessary. That was a justification that came about for the restrictions to free speech. Did one see the kind of attack on free speech at that point that we see today? I don't think we did. The fact is that today we are seeing an attack at a very different level. This is something that has been recognized. And we need to also look at why it is that we are looking at such a serious level of attack. Why it is that free speech is so threatened today as opposed to when perhaps 1950. Interestingly, like you say, communism is something that has always been seen as a sort of threat because it challenges the structures of power, at a very foundational level. It looks at a class struggle, which is something that pretty much at that point there was complete discomfort with. There's no two ways about that. But today we see an attack on free speech at a very different level. And how do we understand and how do we understand why that is happening today? And that is something I think that we need to see, and that is something that I think we need to recognize.
Okay. So let's talk about this First Amendment a little bit more, right? Um, the First Amendment is triggered by a man called Romesh Thapar. Thapar was born in 1922 in Lahore to a Punjabi family. He comes from a fairly wealthy and illustrious family. His uncle was a chief of army. In fact, famed journalist Karan Thapar is his cousin. Historian Romila Thapar is his sister. And Thapar, like many young men of the time, was fascinated by communism and was a lifelong communist and a member of the CPI. In 1950, Thapar was the editor of a communist magazine called Crossroads, which was pretty critical of the central government's policies, going back to preservation of power. Communism was finding followers in parts of Madras Presidency, which includes parts of modern-day Tamil Nadu and Andhra Pradesh. And a full-scale armed peasant communist rebellion was taking place in nearby Telangana. And the government feared that this magazine and the communist views it propagated would further stoke communist sentiments, and they passed the Madras Maintenance of Public Order Act in 1949. Under this act, they imposed a ban on the circulation of Crossroads, and that in March 1950. That very same month, Romesh Thapar challenged this order and this ban as violative of his fundamental right to speech. In May 1950, merely 2 months after Romesh Thapar files this case, a landmark judgment of the Supreme Court comes out, refers to the freshly concluded Constituent Assembly debates, and concluded that the debates indicated that the criticism of government was not intended to be a restriction of free speech. There had been other readings by the Supreme Court which had similarly upheld free speech. There was a reading by the Supreme Court to uplift the ban on a right-wing publication. Now, this publication was banned because the government feared that it would stoke communal tensions. But the Supreme Court said that was part of right to free speech, so it could not be banned. In Bihar, the High Court refused to squash a public pamphlet that incited violence. And thus, in May 1951, the central government brought the First Amendment Bill. Now, this First Amendment included many different amendments to the Constitution, but one of it was adding a clause which would limit the freedom of speech in the interest of the security of the state. And the Constituent Assembly also served as the first parliament of India till the 1952 elections could be held. So, in a sense, the very body that had fought over the free speech restrictions, was now asked to further amend it a mere 15 months after it had passed it. Both the left and the right were united in their opposition to this amendment, but ultimately it was a numbers game. The government added a qualifier. It said reasonable restrictions in the interest of the security of the state, and the amendment was passed, 228 to 20. To me, it's fascinating that the First Amendment is actually a response to liberal courts and a liberal understanding of free speech. I'm curious, Maitreyi, what your reaction to that is. How has the court changed, or has it remained the same, or the court's approach changed since these early judgments? And what is the role of the court really in upholding or restricting free speech?
You spoke about Romesh Thapar and you spoke about Brij Bhushan and the response of the Supreme Court to those judgments. And certainly it was something that really took forward the idea of free speech itself, which is something that's very essential. But I think the thing with courts is that courts are not necessarily a kind of there's no uniformity in that sense necessarily when we talk about courts. There are several other factors that kind of come into consideration, whether it is who you're appearing before, who is appearing, who the person involved is. There is several of these considerations also come in that one must really keep in mind when one talks about courts. For example, a few years after you had Romesh Thapar, you had the Supreme Court upholding sedition, you upholding the provision of sedition in Kedarnath. And if you really look at the judgment in Kedarnath, it talks about, it talks about the citizens' right to say or write things about the government, but it cannot be something that goes beyond a point. It cannot be with the intention of creating public disorder. So there are restrictions that are put way back, even in the 60s when you had Kedarnath. Then you have, similarly, you have judgments of the Supreme Court, for example, where in EMS Namboodrapad's case, where they actually looked at the question of contempt of court. And he was, of course, interestingly, he had spoken about the judiciary and how Marx and Engels considered the judiciary as an instrument of oppression, and how one has to look at understanding the judiciary. And they of course they uphold the conviction, they reduce the sentence that is there. So you have these various judgments even then, which don't necessarily only look at the promotion of free speech. So I think they are understanding courts in one way and saying that this is how the courts were then, and then there has been a complete shift. I think it's may not necessarily be the way in which we can understand how courts have really looked at free speech. You look at, like, it's similar to what we have now today. Also, you have several judgments that come out which talk about the right of free speech. There is a judgment where the Supreme Court says that you don't restrict the person, but there is a positive duty and obligation on the state to ensure that there is a conducive atmosphere that allows for for free speech to thrive. So there is a positive obligation that is placed on the state to ensure that the that people are able to freely speak. The idea of free speech and expression can actually blossom in that form. But at the same time, you have various other judgments that don't necessarily protect the right to free speech that one sees in the courts. So, for example, you have the initiation of contempt proceedings against comedians. You have Prashant Bhushan, who is held up for contempt. So in many ways, the court at one level, depending on various circumstances, on various factors, there have been judgments which talk about the idea of free speech and the need to promote it. And the other hand, you have the state. I mean, you have the judge, you have the court itself taking away this right that is so essential. So I think in that way, I'm not sure that there may be a pattern, there may be a sort of trend, but I don't know whether one can necessarily demarcate it into eras to say the courts saw the idea of free speech that way. But I think it's necessary to really recognize the differences in court itself. Interestingly, when we're talking about courts, there is a judgment of the Gujarat High Court where Justice Ravani, he remarks in that that's a case of that's a case where I think there were some hutments that were demolished, and he talks about the trial court and the order that is passed by the trial court, and he says that he talks about Tahsildar, the courts, and he says psychologically they represent only the caste interest to which they belong. And I think this is something that we all also really need to keep in mind when we are talking about the courts. It's not something that lies outside of society itself. So everybody who's there, whether it's the prejudices, whether it is the beliefs, whether it is what underlies what, where a person comes from, their own socio-economic background, all of this influences the way in which judgments come out. So it's not that, if you give me whoever it is before me, if I have a law, that the law is going to be implemented the same way across the board. That's not necessarily the case. And that's something I think that we really need to keep in mind when we're talking about the courts.
Well, I think that's a really, really important point for us to keep in mind as we look at judgments and what they say, that the court isn't a monolith that is separated from society, that it is diverse, made up of human beings who carry similar backgrounds, biases, opinions, and judgments to all of us, and how that influences in many ways how cases are decided, how laws are interpreted. And keeping that in mind is equally important while we look at these judgments. Sort of want to end a little bit by asking Maitri about your experience with workers' movements, with people's movements. At the beginning of the conversation, you sort of talked about the struggle of the telephone workers union and the termination of certain workers there. But but I'm curious to understand a little bit more, Maitri, about the impact that the restriction on free speech has had in the practice of democracy. You know, if you think of protest and people's movements and workers' movements as essential to the democratic fabric of this country, then how, in your experience, how have these restrictions impacted the practice of democracy?
For when we talk about free speech, the first thing that most people think about are journalists or the press or if somebody who's writing something. But I think the idea of free speech is so much more than that. The idea of speech and expression goes down to it becomes sort of the premise for every right that you wish to exercise. So if you look at, for example, workers and the way in which worker struggles, workers' movements over the years uh, have been denied this right. What is the primary form by which workers are able to exercise this right to speech and expression? And one of the main ways in which that they're able to do that is by organizing, by unionizing. And the right to unionize, the right to organize, the right to for association is so interlinked with the right to free speech that it's very difficult for one to go without the other. And if you look at the way in which this right to unionize and organize has been continuously trampled upon and has been attacked, uh, one can really see the way in which the this core the one can really see the way in which the manner in which this idea of free speech itself has been assaulted. So, for example, if you look at workers' rights, the you look at the organized, the unionized, they come together, they put forth their demands. If like I was mentioning in the beginning, if it is if there are workers with insecure working conditions, you lose your job. If it is workers who may have more secure working conditions, then you have the courts which come in the way and say that you cannot strike or you cannot protest. There are injunctions that are granted against the right to protest. So there are various ways in which one really sees the right of free speech, the right of association, the right of organization really being attacked, without necessarily even referencing to these rights and recognizing that that what is happening is the constitutional rights that are being violated. If you look at the way in which the across the country, the way in which movements have been attacked, there have been attempts to stifle the right to free speech. We don't have to look very far. I mean, if we look at the way in which the anti-CAA protests, the kind of arrests that took place. I mean, you have arrests that took place for people who spoke about love, people who spoke about building, of building building things on the basis of peace, harmony, and arrests have been made targeting particular communities, especially Muslims, and now you have several of them being incarcerated. Look at Umar Khalid and what the allegation against him is. So where do we really see, and where can we place the idea of freedom of speech today, and whether this attack that we see on freedom of speech, we also have, and the need to recognize this as an attack on our democratic ideals itself. And this is not something that's just new. You look at the way in which sedition has been used across against movements. You have instances in Kudankulam where the movement against the nuclear power plant. You had thousands of people. You had FIRs of sedition fight against thousands of people over there. You look at what's happened in Jharkhand, where the Patalgadi movement took place, where They were putting up the parts of the constitution. You had sedition filed against thousands of people over there. You look at the what is happening in places like Chhattisgarh, where there are movements against the against mining companies. You have large number of people being arrested and being incarcerated for several years without even trial. And if you look at statistics of under trial prisoners in Chhattisgarh, for example, it's really shocking the way in which this has happened. So the weaponization of the criminal justice system, the weaponization of the of criminal law to target any form of protest, any form of challenge to the government, any form of challenge to and any movement towards a society that is actually equal. Any movement towards social and economic equality. You will see that there is a you have the use of the state. The state is used to trample upon these movements, and of course, this is the attack on free speech is an attack on democracy. Of course, the attack on these movements has to be viewed as an attack on democracy itself. Not many people have seen this, but we all know about the Bhima Koregaon cases. One of the first arrests that took place insofar as that the incident of Bhima Koregaon is concerned, were 5 workers who were working at Reliance Energy, and they were arrested and they were put in with allegations that they were Maoists. Then the reason for doing that is because they were contract workers who had organized themselves. So one can really see the different ways in which the criminal system is used to, in many ways, not only attack the idea of freedom of speech, the idea of the right to free speech, but effectively to destroy the lives of people and to break movements and struggles. And that is something I think that we really need to recognize, that we really need to see that this is an attack on our constitutional values itself. What Dr. Ambedkar spoke about when he speaks about the contradictions that exist in society, and the fact that there is that there's one man, one vote, one person, one vote. But in terms of social and economic equality, that there is one is so far from it, and the contradictions are so stark. And he says, how long will we live this life of contradictions? How long will we continue to deny equality in our social and economic life? And if we continue to deny it, we will do so only by putting our political democracy in peril. And that is a warning, I think, that really rings true. He goes on to say, we must remove this contradiction at the earliest. This is 950. Or else those who suffer from inequality will blow up the structures of political democracy. So I think that warning of Dr. Ambedkar is something that we have to take very seriously. That you can't have political democracy without social and economic democracy. You can't have political democracy without social and economic equality and justice. And the idea of free speech has to be viewed as part of this. And I think that's something. In today's times, where the constitution and the constitutional values are only up for challenge, people are talking about doing away with constitutional values, doing away with what is there in the constitution. I think that's a very serious challenge that comes on all of us, and I think it lies on all of us really in many ways on how we will ensure that the values in the constitution, that the core values of a democracy will is not going to be thwarted.
I mean, that warning of Ambedkar's is something that is echoed throughout the Constituent Assembly. If you look at the speeches on the final day of the Constituent Assembly, there's obviously a congratulatory note at having put together this document, but also there is a note that this is not enough. Creating this document doesn't guarantee equality, doesn't guarantee justice, liberty, fraternity in any way. And several of the Constituent Assembly members say, like, our work begins now to ensure that these values are imbibed. Dr. Ambedkar, of course, has this warning, and he talks about constitutional morality, that we need to imbibe it. And without that, constitutional values will not have much meaning, or where their implementation and adoption remains a huge question mark. I think that's a fantastic note to end on. Maitreyi, this was such a great conversation, I think, for us to place not just the Constituent Assembly debates on the right to free speech, but to locate them as an instrument for advocating for social, economic, and political justice. Thank you so much, Maitreyi.
Thank you so much.
You can listen to this podcast on Suno India's app, now available on Google Play Store or any other app of your choice.